all of you. I mean, as you can see, there's a lot of passion around this subject, and there's a lot of unknowns that we don't know. I was going to take the liberty and start off with questions, but I think this might be some place where all of you may have some questions. So I'm going to go ahead and see if there's anyone who has a question, a burning question. And if not, then I can definitely ask my questions. Deanna? Hold on. We're going to get you the mic, please.
Ask folks to please identify themselves, their affiliation. Please, one question.
Yes, another rule person. Deanna Oken, Adusi Mastriani in Schaumburg, and thank you very much, really informative presentation. My question is about the minimum wage requirement and what impact you think that will have, both in terms of how businesses make their decisions, how the impact in the supply chain, and then the impact on labor in both sides of the border, I guess. Thank you.
So the $16 minimum wage requirement for auto, it's part of the rule of origin, sort of built into that. I think it's 40% of autos need to be made by workers making at least $16 an hour. I mean, I actually am going to reserve judgment about how impactful this will be, but I think, there are some signs that it's not going to cause a tremendous amount of, production moving from Mexico to the United States, or even wages going up. I think there'll be some shifting around. Certainly in Mexico, maybe more hiring of higher wage, of more managerial, scientific, or whatever kinds of workers. I don't think you're going to see factory level workers in Mexico earning $16 an hour. And right after, as this was being negotiated, GM was still moving production from the U.S. and Canada to Mexico. So I think this is one of those things. The rule of origin is, I think everybody knows, is very technical and very malleable. That the companies have a lot of ability to use those rules of origin in ways of defining, what's in your numerator and what's in your denominator. But maybe it'll put some pressure, and maybe it'll be a little bit helpful in terms of slowing down some of the movement of jobs out of the United States. But one of the reasons, and I'm just going to say this as a political person, that you haven't heard the companies objecting very much, the auto companies objecting very much to that provision. And my experience of working on the Ex-Im Bank Advisory Board and so on, is the companies can't stand to be told by the rule of origin to move anything from one place to another, and so if they don't complain, it's probably because it's not binding on them. But that may be too simplistic, and I don't know, Ricardo, maybe you have some insight.
No. Basically, the minimum wage only applies to whether to comply or not with the rule of origin, and it has certain rules on certain parts of the vehicle has to comply with that threshold. So I don't think it really impacts directly.
It's not going to be a game changer.
It's not going to be a game changer.
Okay, is there another question? Let's go right here. Mr. Williamson.
Irving Williamson. Ricardo answered my question that was burning, but I was wondering, why didn't any of the others address the possibility that a Mexican company could file a complaint here?
I had two observations about that, and I think Carol's probably going to get to one of them, which is read the footnotes, right? So there is an asymmetry in how this mechanism applies to the United States and Mexico. In the case of Mexico, it applies to any covered facility, which is just about any facility, with respect to laws pertaining to collective bargaining and freedom of association. With the United States, in the case where the United States is respondent, or it's a United States facility that is respondent, it only applies with respect to an NLRB enforced order. So there's a predicate, which is there has to be an NLRB enforced order. It can't be any facility. Second point I would like to make, though, picking up on Ricardo's point about who can bring a complaint, and this pertains more to the statute, to the USMCA implementing act that I think the Senate is about to vote on today, which is there's no standing requirement in there, right? To bring a petition to the Interagency Labor Committee, you have to be a member of the public, not the U.S. public. It could be the Mexican public, it could be the U.S. public, it could be a third party. There's no standing requirement, so an individual worker could bring a complaint, whether it's in Mexico or in the United States, and the committee has to act on that complaint. There's no discretion to dismiss a complaint out of hand. I suppose in implementing regulations violations, this committee could decide what constitutes a complete complaint and what might be frivolous on its face. But there's no standing requirement. I think that's quite important. So you could have workers in Mexico at covered facilities in Mexico bringing complaints to the U.S. Interagency Committee in order to have that committee come to a determination as to whether the United States should be engaging with Mexico on this rapid response mechanism.
That pretty much covers it, except just wanted to add a slightly finer point on what an enforced order of the NLRB actually means. And that means that the NLRB decision has been appealed to a U.S. Circuit Court. That almost never happens. If we look at how many cases kind of on average per year, roughly between 60 and 70. You think of all of the companies in the U.S. to have only 60 or 70 that may potentially be covered, and then you reduce that number further. Some of the cases are not against employers, but they're against unions, so that will reduce it further. And then the covered facilities must be in priority sectors. Priority sectors are also articulated in the protocol, and they include manufactured goods, supplies, services, and mining. So the big gap that jumped out at me right away is agriculture is not covered. From a Mexican, that's obviously huge. And then there are things like oil probably not covered either, which is big for Mexico. But I think that's that.
Just to add, and there are some caveats here, because first of all, one thing that we may need to be realistic is that the rapid response mechanism only applies to certain one violation, freedom of association, which I don't think it will be a great deal. So what I see more is a case coming on the substantive violations of the labor law, not as much as going or using this mechanism. What I do see is what I call the backdoor, which is the expansive provision, which tells you that if you have a finding of a panel saying that you violate other provisions of the labor, to that provision, the rapid response mechanism will apply to that. So I see more in that way. Now, let me address something that has to do with evidence, and I think that raised that, and I think you have to, it has to do with implementation of the provisions, and it's interesting, because at least a Mexican labor worker working in a facility and going to the consulate will say no if someone tells, okay, give me a testimony and sign it, that you have been violated or your rights have been violated, because of course of jeopardy of what you know. So I do see that this anonymous testimony provision comes in, and it will be quite interesting how that is implemented to protect due process rights and to allow the panel or tribunal to have sufficient elements on that. So it's going to be very interesting, especially on this side, how you handle this anonymous testimony, and that I think.
I wanted to add one piece about this, because I think it's a really interesting question. It's a really important question. I think Irving knows that, over many years, the AFL-CIO's position has always been that they would welcome a case being brought against the United States for violation of international labor rights by Australia or Canada or Mexico or one of our trading partners with whom we have a trade agreement. And most of the trade agreements we have done up until now, the labor provisions are a two-way street. They apply equally to the United States. And so I think that is another innovation, not maybe a good one, where this USMCA is more one-sided, that it's asymmetrical in terms of the application. But I think in this case, and I think it's really important, one of the points that Ricardo made about how frequent the violation of U.S. labor laws or Mexican labor laws is. That should not be a frequent thing. And so, one of the goals here is to use the leverage of a trade agreement and the economic impact and focus that comes from that, and the threat of losing market access, to force companies and governments to do what they ought to be doing. The U.S. government ought to be enforcing our labor laws better, and companies ought to be abiding by labor laws. But I think, in that provision, I think people are right. The rapid response mechanism is less likely to be used in the United States, unfortunately. But I think that the migrant worker paragraph could be interesting. You know, it does say, parties recognize the vulnerability of migrant workers with respect to labor protections, and each party shall ensure that migrant workers are protected under its labor laws, whether they're nationals or non-nationals of the party. This is actually a little bit in contradiction to a Supreme Court case, Hoffman Plastics, where it was found that I think migrant Mexican workers were not receiving the full protection of U.S. labor laws, and that was a position that the U.S. labor movement objected to very strongly. They want all workers who are in the United States to be protected. So maybe this will create an opportunity for a useful case and some attention to that issue.
Hi, thank you, David Nelson. Thank you for your presentation of a very complicated topic. My understanding is that the RRM is to be applied when Mexico fails to fully implement its labor law. My understanding is that the Mexican labor law, the new law, has a transition period of, I believe it's 4 years, or maybe 5 years. Does that mean that the RRM will not be utilized until that's fully implemented? So it'll be 4 or 5 years, or is it possible that it would happen, that some of these high-profile cases might be done sooner, even though the defending company might argue, hey, it's not fully enforced yet?
No, that's a fantastic question. So the 4-year implementing period is with respect to the establishment of the new institutions that are required to be created under the constitutional labor justice reforms and then the implementing legislation from May of this year. The rights, the collective bargaining rights, the freedom of associational rights, those are there. I mean, the constitutional labor justice reforms, there were some substantive improvements with respect to protection of freedom of association, collective bargaining, but the big improvements were with regards to the enforcement institutions. So the creation of the new federal labor courts, the creation of state-level labor courts, the abolition of the conciliation and arbitration boards, and the replacement of those with the courts and state-level conciliation centers. That phase-in is for the creation of those institutions, not for phasing in the protection of the rights that those institutions would be enforcing. So my interpretation is that this rapid response mechanism could be used from day one with regards to those particular rights that are covered.
Thank you, right? Great Mexican lawyer.
Sorry, I guess we should turn our to you.
No comment.
I'm sorry, wait, Jason, do you mind just waving? Can we give it back here? I think, Evelyn, just raise your hand 4 or 5 times.
Yeah, hi. Thank you. My question is this. I think it's Article 3 that says, upon delivering the request to the respondent party, the complainant party may delay final settlement of customs accounts related to entries of goods from the covered facility. And it goes on, settlement of such accounts must resume immediately upon agreement by the parties that there is no denial of rights, or a finding by a panel that there is no denial of rights. My question is, I interpret this as mandating a suspension of liquidation. So my question is, how does the lodging of a complaint affect the duty assessment process? And how does it affect your dealings with CBP?
So you're right that this, in U.S. customs law lingo, this is about suspension of liquidation. There is a provision in the implementing statute that authorizes customs to suspend liquidation upon the lodging of a complaint. What's not dealt with, well, there are a number of issues. I think Nicole or others could probably speak to this in greater detail, and that is, how do you identify the goods and the particular entries for which liquidation should be suspended, number one. Number two, and this comes back to a point I made at the tail end of my remarks, is what if we're talking about a good that is not itself traded? What if it's incorporated into some other good? So I think that the suspension of liquidation provision is of marginal utility. I think it's only going to be relevant in the very straightforward scenario where the facility in question is producing a good that itself is traded, and where U.S. Customs is able to identify with precision the entries that include goods from that particular facility. So I think it's an interesting provision. It's an example of what I was referring to when I talked about the complainant really driving the process forward. But in practice, I'm not sure how often that will be used.
And it has also a practical problem in the Mexican side, because we don't have this suspension of liquidation notion under Mexican customs law. So there will have to be some sort of implementation within Mexico in order for this to be operative in Mexico.
The only other thing that I would draw your attention to is, as Ted said, there's certain circumstances when you might be able to suspend it, and whether or not it's an input into a finished good. Could you also suspend the liquidation of the finished good if it used an input that was made with the facility that violated it? I think that if we take a look at what the implementing legislation says, where they have clearly drawn some sort of a link between all the labor issues, and they drew in the issue of forced labor on this, I think that what I see, my predictions for the future is that Customs will then take a look at what's going on vis-a-vis these RRLMs, which gives them an opportunity to take a look at potentially using Section 307 of the 1930 Tariff Act, which allows them to issue a withhold release order and block any type of goods in whole or in part made with something that might be a violated good. And yes, in the way back, and then we'll come back up here to the front.
Thank you. Ken Roberts, Mondelez. And my question, Ted, is what you advise companies with facilities in Mexico, assuming those facilities are compliant with Mexican law? And is there a risk retroactively to transitioning from, say, inactive to active collective bargaining in that sense? Many of us have gone to comply with the Mexican law, and just wondering where this entry into force will affect that and what the risk is retroactively.
Well, let me start with the second part of your question. I don't see a risk with respect to retroactive conduct. So I think the agreement and the implementing statute apply with respect to conduct going forward. Certainly if you have a covered facility that is not complying with local law with respect to collective bargaining or trade association, and that failure to comply is in existence on the day that USMCA enters into force, I think it's potentially liable. The difficulty for knowing how to advise a company, whether it's an actual owner of a business in Mexico or a consumer of goods being produced by a facility in Mexico, is we don't know how this is all going to work in practice. I think until we sort of see some examples or see how this interagency committee, now again back to the statute and not to the agreement, how is this interagency committee going to field these petitions? Are they going to get tens of petitions a year or hundreds of petitions a year or thousands? Is this going to be like the 232 steel and aluminum exclusion process where the Commerce Department gets tens of thousands of applications? I think until we know what the volume looks like, what a typical petition looks like, and how the U.S. government and the Mexican government engage in the context of particular complaints, and what the U.S. government considers to be a credible complaint. What will it take for the U.S. government to form a belief that there has been a denial of rights? I think until we see these things play out in real time, it's going to be very hard to know how to advise companies.
Okay, and thank you, Jason, for your patience. Can you come up here, please?
Thank you. Jason Kearns with the International Trade Commission. Mr. Ramirez, I think you made the point that in a manner affecting trade or investment, I think is now more of a presumption that the violation does occur in a manner affecting trade or investment. My question is that really, and I think you suggested that maybe a step too far, but is it really all that different than the WTO DSU Article 3.8 that basically says when there's a violation, we can essentially presume there is nullification or impairment of a benefit, and it's up to the other party to rebut that presumption?
I'm not going to talk about WTO. I promise myself. At the end is, and that goes to the Guatemalan case on the presumption on a manner affecting trade. But at the end is what do you need to show that is not in a manner affecting trade when you have a standard that says that in a manner affecting trade relates to trading goods and services. So at the end, we will have to see how panels interpret that, because I think sustained and recurring as well has a very complicated definition or sustained. When are you talking about 2 instances? Are you only that's the standard? So at the end, how do you enter into this factor of in a manner affecting trade into that? How do you factor that in a manner affecting trade? When you have not, the company has not, and I'm talking about the shoe company, how do you address the case of a shoe company that has not complied with Mexican labor laws, but does not export one shoe to the United States or to anywhere? It just sells shoes locally. So when you give that presumption, the Mexican government will have to show that it's not in a manner affecting trade. But if you link the way the new chapter is structured, I don't think you can rebut that presumption. Because the only thing that you need to show is that the shoes are traded between Mexico and the United States, period. So I think it's open to interpretation now. Well, that's at the end. If that's what the NAFTA, what the USMCA parties wanted, it's fine. But at the end, you have to be aware of that. So if you don't, under the way the chapter is drafted, a shoe company that has never exported to the U.S. could be a basis to initiate a case, even though that company has never exported. Now, if you link, there could be other interpretation, but that is to me the presumption. I think they're making a presumption that could never be reversed.
If I could, and as a user of the labor chapters in trade agreements, the question is whether this should be an insurmountable obstacle to show in a manner affecting trade or investment between the parties. And my view is that, first of all, we do have a global economy now, and so shoes that aren't exported from Mexico still, are in competition with shoes that might be imported from another country. I don't think it's actually ridiculous to say that, when we're talking about these labor rights cases, one thing that you all should remember is that, there's never been a sanction, a trade sanction imposed in any of the labor chapters that we have to date. And so we need to strengthen our ability to use these labor chapters, not weaken them. So I think this is a step in the right direction to remove one of the obstacles. You mentioned the sustained or recurring. And, I think that's an interesting question too, sustained or recurring, not sustained and recurring. Yeah. And in my view, recurring is twice. It doesn't have to be 10 times. Like if you wanted it to be 10 times, you should say it's 10 times. Recurring is more than once, it's repeated. That's more than once. And so, my view of having looked at these cases, a lot of cases over the course of 25 years, many of them have been thrown out on technicalities where there are real egregious problems. Workers are being beaten up and fired and sometimes murdered for trying to exercise their legal rights. Whether, and these are, I think the idea when you have these trade agreements, countries are tying their economies together in a very important way, and they're making commitments to each other. And so, trying to say it doesn't matter that they, busted the union or beat up the workers because they weren't exporting the shoes, but the shoes are part of the global market, and I think it's not ridiculous to think that we should have an expansive view of how we interpret these.
Let me just give you the other side of the coin. Agreeing with you, because you are looking at it from a good intentions perspective. I'm looking at it from a lawyer's perspective. And imagine a shoe company in the United States who wants to initiate a case against Mexico on shoes. And they will say, find me a case where there's a violation of Mexican labor. And you only find these 2 facilities in Guanajuato, or León, where they produce shoes in Mexico. Very small facilities. And you find the violation. My problem is that the system could be abused. And your good intentions, which I agree, which is why the good intentions, let's protect labor rights, blah, blah, blah. That's fine. I'm all for that. I'm all for that. The only issue is, how did you look at the flip side? I think that the system can be abused. And I think that's where the presumption comes in. You don't need to show now anything. I think it will be very insurmountable for a Mexican company given the way the text is drafted, to overcome that presumption and say, no, no, there's no violation, even though you produce 100 shoes and you don't export them. So,
If I could say one more thing in response to that, which is that, sure, there is a possibility of abuse, but I don't actually think that is the pattern of what we've seen in the past, that companies, basically shoe companies in Illinois have more things to worry about. They have other tools that they can use that are much more powerful. And I think, as Carol said, bringing a pretty weak case where there's not much of a connection, where the abuses aren't very strong, it's expensive and it takes a lot of time, and it's not going to be worth it in the end of the day. So I think when you look at the big pattern of the world and where the abuses have been, I think it's much more the case that workers and their rights and the enforcement of labor laws have been under attack globally, and we need more tools to protect them, rather than that companies are, exploiting some little loophole. I just don't think it happens that often, and there's been some research done. Kim Elliott and Richard Freeman wrote a whole book mostly about the GSP labor rights provisions, but they did look into a couple of decades of the use of those provisions to find that there was not a pattern of protectionism in the use of GSP labor provisions, that in fact those cases were brought when there was really an egregious violation of rights. It wasn't necessarily where there was the most economic impact on American workers. And I know from my experience with that at the AFL-CIO, we only brought a case when we thought we could win, when the workers were really in dire straits, and when the union or the workers in that country was asking for help and asking for approach. So I agree with you that there is a possibility of abuse, but I just think it's very remote.
I just want to add one thing really quick. I think we should also remember why we needed a new definition of a manner affecting trade, and why we came to the point of having this burden shifting that we now have. I mean, if you put forward the hypothetical of how difficult it would be to show that a particular labor abuse affected trade flows, you reduce the price of the good that went into the international stream of commerce. I mean, let's use the example of discrimination. Let's use the example of sexual harassment. If you have a maquila that is engaging in, where the managers are engaging in widespread sexual harassment, a case of discrimination that falls under the labor chapter, to demonstrate that conduct somehow affected trade by changing the price to produce the particular commodity that was being traded is an incredibly difficult exercise. So I think in order to ensure that difficult exercise did not prevent meaningful application of the labor obligations of the labor chapter, we needed to redefine what a manner affecting trade meant, and that's how we got to where we are, I think.
Yes, last question, sorry.
Lori Wallach from Public Citizen.